This is Dish and Dirt with Gary Pickren, South Carolina's only podcast dedicated to the real estate agent craft. And now, the host of Dish and Dirt, Gary Pickren.
And greetings, welcome back, everyone, to another episode of Dish and Dirt. I'm your often opinionated but rarely wrong host, Gary Pickren, coming to you from Columbia, South Carolina, the offices of Blair, Cato, Pickren, Castellan. This will be the third week of February 2025. We are back with one of our favorite guests I've ever had on my show. We've gone 3 weeks in a row of having national guests discussing some very important topics in real estate, and today is no exception. Of course, y'all recognize Leo Pareja. He is the CEO of eXp Realty, and he's back on Dish and Dirt to talk about clear cooperation. He was on back in August talking about his new compensation model at eXp. Well, I'm sure we'll ask him some questions about that as well. And that, by the way, was our #1 episode of all time when Leo was on there. So he made a big show for us. One thing I recently learned about Leo that I did want to share is the SP 200 ranks him as one of the most powerful and influential executives in the real estate brokerage arena. And he's held that title 5 times, which is almost like Ric Flair now, Leo. You know, Ric Flair is a 14-time world champion. You're now a 5-time most powerful and influential.
I think this actually makes it 6.
It's up to 6 now. So you got 8 more to go to be Ric Flair level. Well, Leo, it's always a pleasure having you, and the ability to talk with you and pick your mind is always an exciting time for us. So thanks for coming on.
No, my pleasure. I really enjoyed that conversation we had back in August. I think it was a very important and timely one. You know, what I think folks don't expect is, you know, you and I text back and forth, we bounce ideas, and I'm always game to have conversations with smart people I respect.
Well, I appreciate that, because after our conversation, I wasn't expecting any follow-up, and the next thing I know, I've had 3 or 4 text messages with you very shortly after that, and it made me feel good. So I really appreciate you. Have one of the biggest and brightest minds in real estate, and you reaching out, getting my thoughts and opinions on something was an honor. So I really appreciate that. It's very nice to work with you. We're now 6 months post-settlement. I wanted to, first of all, get your ideas of kind of the state of the real estate agent market since Sitzer Burnett settled back in August.
If you recall, I may have said it on your podcast, but I'm sure I said it on multiple others. I felt that we were going to go through a messy middle, right? So in my headache is a multiple of 50, right? I would say some states nailed it and some did not, right? Mm-hmm. So it was allowed almost 60, 90 days where the volume actually got worse after August 17th, where I was on the phone with association and MLS executives explaining very basic things. But, you know, in a very good way, I feel that we've seen a lot of states shift their contracts, drop cooperative compensation out of one of the selected boxes. And most notably, we saw Missouri, St. Louis, Kansas. And, you know, this case was tried, be the first ones to shift their position and change how their forms are done. But what I said prior to was my hope that this was going to be more of a Y2K moment. So, you know, for the listeners who are not as gray as you and I are and know what I'm talking about, you know, in the year 2000, there was this panic moment that the computers were going to glitch because they were not set up for the 000 part of the clock counter. And literally there was this paranoia that satellites were going to fall out of the sky. And there was this mass fear, which mobilized a lot of people, right? Like I was, you know, in my teens when it happened, and I remember there was mass worries. And I think moments like that is what we got in real estate, where collectively agents listened to their brokers and or other brokers if their brokers weren't being loud, like I was. And we figured it out, right? And I'm really proud of the work we did as a company. I got many calls from association leaders and MLS leaders saying, hey, by the way, your agents are more versed in this than my staff, right? And so I think it was a moment to just really be as open and transparent as possible. We open sourced our forums. We made all of our content, you know, on YouTube versus having it behind our LMS paywalls. Because I think what was most important is actually serving consumers, right? Like, this is not a moment to like beat your chest and I'm wrong and you're right and you're stupid and I'm smart. It was like, hey, what's the best thing for consumers? You know, you and I have very aligned thoughts. I think these were ambulance chasing, money hungry attorneys that don't give a damn about consumers or our industry.
100%.
Very clearly, I think the settlement is confusing, right? You have paragraph 19 completely disagreeing with paragraph 32. And, you know, where we landed and you and I aligned on it is more of a reaction to what the rules we were given. Mm-hmm. If you and I had a blank sheet of paper, I think we would have come up with very different rules, right? And left most of it alone because it worked. and it was good for the consumer. So, but you can't kind of rehash things you can't change. And what I do think that was good that came out of it is a forced compensation conversation, right? Like, I do think there was not enough clarity for the buyer on who paid who and what services were rendered for what fees, right? So the fact that there is now communication and clear understanding, I think, is a good thing. The thing I also said back in August is by this summer, when we're onboarding new agents and we tell them how we do things, they're going to go, wait. You're telling me last year you would stick a stranger in your car and you didn't know how much you were going to make? And like the listing agent decided for you? Everything is customary in what we experience. So where I'm feeling right now is I feel like we're on the other side, right? Like it's working. Do I think some states are still not getting it? Yes. But that's why I wrote my own forms, right? Just because I did not trust that they were going to get it right. And we did not have the ability to wait. So that's where we got into the form business and open source them as best as possible. But for the most part, I feel like we're on the other side of it and just trying to continue to serve customers in the best way possible.
I think the frustrating part for a lot of real estate agents was that the rollout of it was so abysmal, and the fact that you had very little guidance coming down from NAR. It seemed like the states, and bless the state's hearts, like SCR, South Carolina Realtors, did a tremendous job of trying to get the information the best they could, but there wasn't this rollout from NAR. Maybe they were just scared to do it. But, at one point they were telling you, well, if the compensation that you've agreed to in your buyer representation agreement is X and the seller's willing to pay 3X, just go in and amend it. And now we're learning that, no, according to Catchmark, you can't amend it ever, which is absolutely not right. He lied to the court about that. I mean, I don't know any other way you can say it. He said you could never amend it. That's not true. If you add additional services, then you certainly could amend it. But if I'm representing somebody at 2X and then all of a sudden now I find out they're paying 3X, I can't say, hey, I can pick up another point. So you increase this and change it. And so I think that was a lot of the frustration that the lawyers had and the commissioners had, was how bad the information was coming out.
Yeah. And again, I'd like to remind everybody, whether this is not a law change, right? This is a settlement to a plaintiff's act, right, that we are agreeing to participate in. And again, there's lots of opinions from the plaintiff's attorney side to outside counsel who's quite loud. And, at the end of the day, it's like, hey, does this follow statutes of frauds? Do you have meeting of the minds? I go back, I'm not a lawyer, but I like to, think I'm articulate enough to read stuff. And it's like, okay, what's the definition of meeting of the minds and a contractual obligation? If both parties agree to things, can you do certain things? So I still think we're going to be learning and having precedent set. And I really think that there's going to be varying case law in each state, right? Because states can now come up with laws that supersede precedent set by these rulings. I think we're nowhere close to done, but I do feel like we at least have kind of a path forward, if you will.
One of the great things we did at the real estate commission level here in South Carolina is when you look at the touring agreement, and that term's never even used in the settlement, but the result was that having to have a touring agreement. In South Carolina, we're an agency state, so you can't provide client services until you have signed agency already. But what we were able to do is take our brokerage relationship disclosure form and add the necessary language that would comply with the touring agreement. So we basically killed two birds with one stone. And that was one of the wonderful things that was nice to be able to see that the Realtors Association can work with the commission and come up with some workable ideas. So I think as we continue to go along, there'll be some additional things. Last week, I had James Dwiggins on the show, and I appreciate you setting me up with James. And the two things that we talked about really were the threats that I believe are facing the real estate industry in 2025. I think the two biggest threats are the possible ending of clear cooperation and the continuance of the use of broker-to-broker compensation. And I know you're 100% against broker-to-broker comp, and we'll hopefully talk about that at the end of the show if we have time. But today I really want to talk about this threat to CCP. I think it is the biggest threat that we have, and I think it's the biggest possibility for another massive lawsuit 2 or 3 years down the road. Where do you stand on clear cooperation? What is your opinion of it?
Yeah, no, I have not been shy as usual, Gary. I think it's foundational to what we have in this country, right? So I'll give you a couple thoughts on it. One is, you may not know this, but I've spent 10 years of my life building software for MLSs. I'm actually more well-versed in MLSs than the average real estate CEO, just because I built business rules for them, right, and how they operate. The camp that's against it, I think, oversimplifies it for self-interested reasons and says it's just a database. It is not just a database. It is a cooperative group of folks who come together, who are competitors, and agree to a certain set of rules of engagement to share data, right? An MLS database is a completely reduced version of that. The average MLS in this country has 2,000 business rules. And we don't actually appreciate the totality of the value of that because we take it for granted. So I operate in 24 countries, including the US and Canada. So 22 outside of North America where we have organized real estate. So in the south of France, I had an agent. I was at an event over the summer who ran up to me because she used to sell real estate in Southern California. And she goes, Leo, to get ready for an appointment with a buyer who's moving from the States, who wants to retire in the French Riviera, I have to go to 9 to 10 websites to have an idea of what may be available inventory. Completely siloed and ranging from portals to real estate company websites. It is inefficient. It's horrible for the consumer. The fact that we take comps for granted, right? Definitions of what we agree on, right? Like, for example, in the DC metropolitan area where I grew up selling, and I think it's the same in the Carolinas, when you see square footage, it does not include below grade square feet. You and I take that as dogma, Gary, but that's actually not a law or a rule. There are parts of this country in the West Coast that square footage includes finished square feet in the basement. It's not right or wrong. It just is, right? It's what the local groups of agents who compete and create comps and then create value and create appraised value agree on the definition of things. A bedroom isn't just a generic thing that we call a bedroom. It's got a window, it's got a door, it's got a closet, and that window actually has to have a windowsill no higher than 44 inches from the bottom of the windowsill, and it has to have reasonable egress, which is defined as 60 feet or more, right? Like if you show up and it turns out the house really has a 1 bedroom and 2 dens, right? Because they have no windows or closets. MLSs are the ones that enforce all this. The reason I'm going all the way into that level of detail is because without MLSs, we don't have any of the standardization that we see in North America. And I go there because as sophisticated as markets as Japan and the UK and Australia and continental Europe, France, Portugal, Spain, we don't have that, right? And I've been on stages most of my career, and I've said a lot of things that have been recorded just like this. And I used to say, Gary, that the reason why, and I'm saying this from experience, because I actually spoke to the Japanese government, the Australian government once upon a time where they were saying, hey, we want to bring your technology and set up MLSs. And I said, it's not the technology. You need organized real estate. And I said, and they said, well, how do we do that? I said, it's a two-sided coin. And I said this 10 years ago, so I'm happy to repeat it now. And the first part of that coin, I said, was cooperative compensation. And the other flip side of that coin is mandatory participation, right? It's a two-sided coin. Well, just so anyone who's not clear, we lost half of that value proposition on August 17th. Full stop. And I'm not debating the merits of it. I'm just saying that was part of the value proposition. And the other thing that's holding organized real estate from a cooperative data sharing perspective is mandatory participation. And CCP was passed in 2020 and basically states that if a property's publicly marketed, it has to be input into the MLS within 24 hours. That is the mandatory participation rule. And I think it's essential, especially in a time where we no longer have cooperative compensation as a tying mechanism for cooperation. And so what is not said, when I think debated, is the fact that one, it's a complete and total record, right? When you go to list a house in Belize, and I'm using that example because I sold my parents' house there, it's settled in mid of 2024. Gary, how long have I been trying to sell that house? Take a guess.
2 years.
4 or 5 years.
5 years. Good
And
gracious.
the reason I say 4 or 5 is because we put it under contract and it took me like 18 months to get it to the settlement table, right? We went through 4 different brokers, local and franchised. I actually know a thing or two about real estate, so I was asking the right questions. But
Yes.
when I was interviewing the agents, we were hoping that their WordPress website had the right person type in into Google and that house show up, and then that buyer call my listing agent because there was no cooperative compensation, there was no broker, buyer representation and listing representation. And it literally took almost 4 years. And once I got under contract, it took almost 18 months because of financing issues and appraisals and valuation and all that stuff. And maybe the other side can say I'm being dramatic, but that's what MLS brings us, right? I've said this, and I'll say it on the record here with you. We enjoy the most complete and liquid real estate market in the country. And this is what I mean by that. There is not a single property, and Gary, I'm sure you can agree with this. You and I could go list any single property in the United States, and with the data that comes from the MLS, figure out the appropriate discount so we can list it on a Friday and get 30 offers over the weekend. And it doesn't matter how much supply exists. So when there's 18 months of inventory, that discount was probably closer to 20%, right? If comps were 200, I'd have to list that thing for like 140, but I could generate 30 offers on any property, any single day. So right now, it could just be the last comp and you'll get 30 offers, or it could be 5% or 10%, but they're based on supply and demand and data. I can make a very educated decision and price it accordingly. And in those 30 offers, one of them will be all cash close in 10 days, right? So we live in a world where, again, depending on your timeline, I'm not saying it can be done, at top of the market retail value, but I could generate an offer that turns a property into cash in 2 weeks. That is purely a factor of having this really robust data sharing market. Secondly, just so the people who are confused and are being self-interested right now, part of the camp is saying, hey, we just want to try it off market before we put it on market, which is the most ludicrous statement I've ever heard, Gary, because the concept of on market is predicated on a market existing. For you to test it off market, an on market needs to exist. Let's just say we all decide to test the on market, off market. There is no more market. It goes away, right? And I've asked NAR, for the folks who want the rule change, what specifically they want to do, and they're like, hey, if they get their way, they want to be able to put the property consumer facing on their own website. And if it doesn't sell in 30 or 60 days for the price they want, they go and put on the MLS. But that still lives under the idea where I gave them my eXp to go with that. That's also the commingling rule, right? So they want to have their exclusive inventory public facing with my inventory. No, that's not how it works. It's a cooperative. If you take it, you must give it under the same rules of engagement, right? It's basic 101. And what that side is not underwriting, because they're not in all the countries I'm at, is the second we do that, the portals win completely. So in the UK alone, I think I spent 1.5 million pounds last year paying for fees to the portals, because the portals charge a monthly fee for active inventory. So for every property that sits active in the market in the UK, I pay £50 a month per listing per month. Right. And by the way, Rupert Murdoch just tried to buy them for $8.3 billion in cash and they turned it down. So it's a profitable
big money maker.
Right. So the only people this helps are probably the portals and companies with vast amount of inventory, which, oh, by the way, I happen to be the biggest one. I am the biggest net winner if CCP goes away. And I'm going on the record to say, I think it's a terrible idea. It's bad for the consumer. Just because something is profitable and good for my shareholders doesn't mean it's good for the consumer in the long run, the American people.
Today, I saw that Compass One, and I'm brand agnostic, so I'm not taking anybody's side as to who the better brokerage is or not. But I know Rifkin has been a very big opponent of CCP, and I have my reasons why I believe he is. I think it has to do with money. But he just revealed today that they're coming out with Compass One, which means they're going to market all of theirs internally before they put them on the market.
Yeah, I think that's asking for litigation. Let's be very clear. I think, one of the amendments that could happen to CCP, because I've been asked a lot, keep it, modify, kill it. And I said, kill it is off the table for me, but I think everything should be reviewed and explained, right? I think if NAR wants to make a bold move, they come up with a national standardized form, very similar to what we have with alcohol and tobacco and drug use. Like, hey, you can partake in this, but just know the statistical facts, which is 7 to 17% of the price of the property may be left on the table, right? There's an interesting statistic that I'd love to find so you can quote it correctly. But I think, anecdotally, anyone listening who's an agent will agree to this. If you're an agent, do you sell your house off market or do you put it on the MLS? As a real estate agent. MLS, we all do it because we know better.
Right.
We know better. You want the most amount of eyeballs to get you the most amount of money. And this is what I've said. I've actually sat across from sellers for 2 decades of my life and actually sold real estate. Not once, Gary, did a seller go, hey, I want you to sell my house, but hey, I don't want you to stick it in the MLS. I want you to give me this number, and I want you don't you dare put in the MLS. Or I'm going to hire somebody else. That's not a thing. That's a self-interested thing, right? Shortest amount of time, most amount of money, least amount of friction, and that comes from the MLS. If we disrupt what's left of the MLS structure, we will actually create more costs. In Australia, which a lot of times gets held up as, hey, very in first world industrialized, high price points, commissions are lower. But people forget to say, but did you know that the seller has to pay out of pocket like $4,500 to the portals up front for marketing placement, right? Like people forget that you need to fully bake costs, right? There are lots of things that we as US agents do that we just think are normal, that in other countries are charged to the consumer a la carte upfront, right? It's like, hey, you want those services? You pay for them out of pocket. We take photos, we market properties, we pay for signs, we pay for lock boxes on a contingency. You're right. As an attorney, that's a very different form of compensation than hourly. So I don't think there's probably enough education and understanding what people are arguing for.
Let's break down some of the reasonings. And the first one you talked about is this fragmentation. I think if we go away from CCP, then we're going to have a bad system. I don't know, what is this belief that Europe and Australia and everybody has it right with the fragmentation of the market? And I think you and I talked last time you were on the show, if I wanted to go look for a property in Madrid, I don't have one centralized place I get to go to. I'm going to wind up going to 30, 40 different websites. And even if I hire one agent, only what that agent knows will be available to me, because they have to go to every single real estate brokerage company's website to try to find out what's going on. Is that a correct statement?
That is a correct statement. And again, I think when the other side of the argument, or even the plaintiff's attorney, because it was used, was talking about compensation, it's not apples to apples, right? I've seen the report that says out of the G7, we're the second cheapest place to sell real estate when you add in all the other a la carte fees a consumer gets charged, right? So it's kind of like that was one of the things that came out of Dodd-Frank. The Tiliform actually showed you side by side what costs of a loan were. So if somebody said, I'll do it for 6, and somebody says, I'll do it for 6, well, what are the points up front? What are the prepayment penalties? That's the rest of the fee structure that I don't think are being taken into account. But again, like just so I'm clear, the people who want CCP to go away are trying to double up more deals to keep more deals in house, which does not benefit the consumer, right? When we talked over the summer about the settlement in broker to broker, I said, hey, let's stop being selfish as business people and say, what is the best thing for the consumer? And I think this is the most anti-consumer thing we can do. Right. I was quoted in the Washington Post, and I didn't mince my words. I said, I think this is one company's very selfish attempt to find profitability at the cost of the American people, right? This is a demonstrably bad thing to do for consumers. And I'm not shy to say it out loud.
And James was as blunt about it as you are. He said, this is basically a company that wants to get both sides of the deal. But when you ask them, and this is the second point I wanted to get to, is how about your fiduciary duty you owe to the seller? And the fiduciary duty you owe to the seller is to get the most amount of money under the best terms. And when you're selling it in-house for 30 days, there's no way that a market of 30 agents can bring the same number and quality of offers as a market of 30,000 agents. So I don't know how they haven't been a response to this.
No, I mean, they just don't answer the question. They use very polite terms like seller choice, right? Like seller choice sounds way better than clear cooperation, right? Like if you're against clear cooperation, that fundamentally sounds wrong because it is wrong, right? So you have to spin it with something like seller choice, right? But how is the seller coming up with the options, right? Like, are you fully disclosing, hey, yeah, we can try it, but by the way, statistically speaking, properties on the MLS get this number, and you just aggregate more demand.
I think the TV shows have hurt us too, Leo, because if you watch these $1 million listings, they're always talking about, we're going to do it as a pocket listing. This is a pocket listing. And so I think the consumer has this belief that when you list my property in Columbia, South Carolina, you should come out and have models and cars and sushi and all these big open houses because they do it on $1 million listing. And oh, by the way, we should have all these pocket listings because they're exciting and they're bringing interest and fun. That's the farthest thing from the truth.
Yeah, I would say the media has done that to every segment of society and every thought process, right? So again, I like the CCP actually allows for pocket listings in office with certain rules. And again, like, look, there should be almost an exception to every rule, right? Like law enforcement's a very real one. Like I've sold properties in Texas, and I've been in conversations where people were like part of border control, and they don't want their name redacted from the public records, as well as a sign in the ground, let alone, visibility on the internet. But for every one of those, that's a single digit percentage of the transactional population, right? If you live in a, pool T built tract home, right? Single family or townhouse, like you want as many eyeballs to see that. It is not a unique situation where celebrity or politician, like, which is the outlier, not the kind of the vast majority of the population.
Does this not speak to kind of a bigger issue? And I was talking to one of my agents here that used to own a brokerage. It seems to me that this whole idea of getting rid of clear cooperation is exactly that. It's the ability to try to get both sides of the transaction so the company makes more money. And I think this speaks to the bigger problem that the real estate brokerage models are failing in and of themselves. I think that the brokerages have, in a race to try to get as many agents as they can, have basically, in some ways, cut their numbers. So, 60-40 used to be kind of the standard for new and younger agents. And now we have agents that are coming out of real estate school with zero experience, getting 90-10 and 95-5 and paying flat fees. And I think this speaks to a bigger issue. And when you start having to look at brokerages or having to get into title insurance and mortgage and homeowners insurance, it seems the model is failing. And so now we're trying to grasp at other methods of trying to get money, even when it's not in the consumer's best interest.
Look, I don't want to make a commercial of the company I represent, because we've figured out how to be sustainable in our core business. What I will speak to with CCP, because I'm not sure I've articulated this anywhere else, so it's important I get it out, is that even when CCP was created, we didn't have mega brokerages like we do today. Like the rule was passed in 2020, and there is court case law you can look up in San Francisco where one company had like 30% market share, and there was a group of sellers who actually sued because of a lot of pocket listings, and they felt they were cheated out of $50,000, $100,000, tens of thousands of dollars. So like the case law is there. But since 2020, when the rule got put in place to today, we went from, in 2020, we were probably 10,000 agents. I'm now 80-some thousand agents, right? Compass is 40,000 agents when they were just a couple thousand agents. Like CCP is actually more necessary today with mega brokerages than it was back then, because the CCP rule of intra office, it was just your office, but now I'm a whole office in a state, right? So the rules of engagement are more necessary today even than 5 years ago. And again, I think capitalism should work its way out, and services rendered for value provided is the way that we should price services and products. But look, I'm not even against, keeping the exceptions to the rule, as long as we have really clear disclosure. If a seller were to sign a bold document created by NAR that says, hey, I'm fully aware of what I'm participating in, and I'm fully aware I could be leaving double-digit equity on the table. You're an adult. You could sell it for $1 if it makes you happy. But where I worry, Gary, is that companies are saying, hey, this is the way to do it. This is the way we do it, and it's the best thing for you, and not explaining to them the potential double-digit equity being eroded because one company thinks this is a good idea.
The two issues I think would kind of go together is, if we do get rid of CCP, a company your size could basically run all the small brokerages out of business, because if you have 80,000 agents, you're getting massive numbers of listings. And if I work for a small brokerage and I don't get to see your listings until they've gone through your process of 30, 60, 90 days, and then you put them on the market, I'm essentially cut out of the market. So I think that's the third issue. And then the fourth issue, which is I think really the whole essence of real estate, is equal access. And when you have a policy that would allow a brokerage that could control a downtown like a Columbia or a Greenville with an agency that, let's say, is mainly a white male agency, how does an African-American female even have a chance to buy it. So it is a fair housing nightmare. And I cannot stress that enough. I've been screaming it from the rafters. This will result in lawsuits for fair housing and for antitrust. There's no ifs, ands, or buts about it.
1,000%. I emphatically agree with you. I did a debate with a couple of broker leaders on Riz Media if you want to catch it. But I actually said that, and the folks from one of the companies were very upset that I said that. And they said, well, you can't just make that statement. I was like, of course I can. If one group of people control inventory that's not shared publicly, by definition, another group of people are going to be harmed. It might not be on purpose. It might not be specifically because you are a bigot or trying not to show it to a specific group of people, but just the mechanism in itself is not transparent. So if this is the other thing I've said on record, and I'll say it with you, Gary, right now we compete on service and value and kind of product offering, right? As agents, when we go sit with a seller or a buyer, if it turns into an inventory war, which is what it will turn into, we are going to create pay-to-play schemes, right? And I can't say it more bluntly than that, right? And I will tell people, hey, have you ever tried to buy a multifamily from a commercial company, right? And they're like, are you using us or not, right? I've had those conversations, and I'm a sophisticated investor, right? Where they're like, hey, am I representing you or not? Because you don't have to use us. Go ahead, send in the offer, see what happens. And then every game's even presented, right? There's no rules engagement, there's no MLS, there's no code of conduct. And so that's what's coming to residential real estate with, 1968 Act and all the protected classes. Like, how are we not asking for a nightmare scenario?
If I'm an African-American male and I'm getting my business from my fraternity friends, my church friends, maybe some organizations that I'm in and that represent my community, have all these African-American clients, how are they going to get to that property that's being marketed and listed by a brokerage that has 6 white guys? It's just not going to happen. And for them to say it's not is absolutely absurd.
You can go down the 7 groups: familiar status, place of origin, all of that stuff. We're very tribal as human beings. We tend to like and work with the folks we feel most similar to and akin to and have the same shared experience as us. But the second that these pockets of inventory disappear are only available through a certain other group. And again, like I've had friends tell me in certain markets that some of these companies are dominant that have this practice. They will literally have to send them out to a friend at that company so they could hope that their buyer gets a house, and they don't even get a fee on it. But they're actually being fiduciary and saying, hey, do you guys have something for this person? But like that just becomes a nightmare scenario. And I've been emphatically and very vocally hoping that this insanity doesn't move forward.
So what's your prediction moving forward for 2025? Clear cooperation survives or doesn't?
I think it does. I think it does because I'm an optimist. I think you've gotten to learn that about me, Gary. Even in the most confusing moments, I just try to say, hey, what logic should prevail? I think there will be adjustments to it, which could be very different than the people who want it to go away think they're going to get. But I think logic will prevail. Look, I've said MLS executives have called me for my opinion publicly, and they said, what do you think? I said, this is the hill you die on, guys. You want my opinion? You die on this hill. Because if you don't, as an MLS executive, die on this hill, this is the end of organized real estate where you add value to the transaction.
Absolutely. Well, let's move over to the second threat. Let's talk about broker to broker. You came on our show in August and said that eXp was moving away from broker to broker. And the reason you came on our show was all the misinformation that was out there saying, oh, eXp agents are cutting the buyer agents out. They're never going to get us paid, which was the furthest thing from the truth. It was listing agent will decide with the seller what the comp is. Buyer's agent will decide with the buyer what the comp is. And if the buyer would like to get comp from the seller and help, they can ask for it in their offer. And I wanted to ask you, it's been 6 months. How has that played out for eXp?
Yeah, and again, the other part that was like the seller can still choose to offer it. We're just saying it's a separate form, a separate part of the conversation. And what really we were moving towards was, hey, we just need the seller to understand that it is now a choose your own adventure path, right? And the choices are, you can offer seller to broker compensation, choice A. You can say, we're open to any and all offers, choice B. Or you can say nothing and hold, your peace and plead the fifth. And the reality that I would educate on these classes to buyer agents, or all agents doing buyer agency is like, have you ever gotten a property for slightly less than list or gotten them to convey the pool table in the basement or a hot tub in the backyard? That wasn't advertised. Did you ever get a 60, 90-day rent back included in the purchase price? Like, just ask for it, right? It's all part of the negotiation. Where I said it then and it played out is, look, at the end of the day, the offer you set forth with that buyer is the offer they can consummate. That could be all cash close in 10 days, no contingencies, or that could be 90 days, 100% finance, down payment assistance, and 6% concessions at close with a home and sale contingency. They both can net you the same amount of money. The seller can accept one as is or counter certain things, right? Or just say, hey, look, they're both at the same price, but that doesn't mean the same thing. So if one has compensation request from seller to buyer brokerage company, okay. At the end of the day, this is what has not changed, Gary. The seller nets X amount of dollars and the buyer has X amount of dollars to bring to the closing table for the monthly payment they can afford. And so luckily for us, we made a very clear line in the sand, which created a lot of turbulence, but I think it was a good thing. Our agents have never been so engaged and asked questions and said, yeah, this makes total sense once you explain it. We actually had a really positive reaction once it went into effect because agents were like, our forms are so much simpler than the state or the county or the MLS or the other companies where it's like, it's a 1-pager for buyer agency. It's a 3-pager for listing, a 4th page if you want to offer seller to broker compensation. And so, I mean, we had agents react so positively. We're like, hey, can you do this form for us? Because it's 12 pages and I'd prefer if it was your 1 to 2 page form version. So it was for me personally, it was an interesting moment in leadership, right? Because it got really loud for me, Gary.
Remember.
And it was one of those moments. I remember I was up all night one night and my wife said, you know, I was all stressed out about it. And she asked me, said, are you right? I said, I don't think I've ever been so right about something in my life. And she goes, then just
do it the right way.
Then just hold on tight. And thankfully, people like James Dwiggins came out and Anthony Lamacchia came out and said, hey, we're actually adopting the exact same policy. But it was very quiet and lonely for a couple of weeks there.
And I think if NAR does not do something about clear cooperation in 2025, then by 2027 or 2028, there will be a lawsuit that is bigger than Sister Burnett. If you look back at what Michael Ketchmark, the asshole, that's how I refer to him as, if you look back at his claim, he's not wrong on this one particular claim. His claim is, why is a listing agent dictating what the buyer's agent is getting paid? And once you went to we're not doing broker to broker comp, a lot of the smaller brokerages in our town did the same thing. And what they're telling me is, I cannot believe I wasted any of my time or any of the capital that I have built up with my seller client trying to convince them before we even put the property on the market what they should be paying the other side. Why am I wasting my time? It has nothing to do with me. And so what they're doing is, my commission to list your house is this. And when an offer comes in, we'll keep an open mind. The most important thing that you said today, it's all about the net sheet. We don't need to say no before we know. We don't need to say, I'm not going to, and draw these lines in the sand, because until we see what the offer is, it doesn't matter. And so I think it's been
You're
the best.
100% right. I have many, many anecdotal stories where agents said, you made my job easier, right? Because I think the consumer gets it. They're like, okay, I owe you this fee for these services rendered. They said, what about the other side? It's like, we will find out, because you don't know. You don't know if they're working with a flat fee agent. You don't know if they're doing it for a discounted rate or what's discounted. That's even up for debate now, right? I've had agents on the buy side tell me they've actually gotten a raise now, right? Because I have many, many stories where they're like, hey, the seller was willing to contribute X and my form says Y. And the part that I think agents got stuck in is like the difference could be 25 basis points, 50 basis points, 75 basis points. And certain price points are like 400 or 500. Maybe that was an additional $1,500 out of the buyer's pocket, which they gladly did because they felt that the service that was explained to them in detail and their services rendered was worth it. So the agents that are highly professional and took a very systematic and articulate approach. I think what really came out of this, Gary, is James founded a company called Raise. I'm not sure if you're familiar with it. It's a company, RAYSE. And he did a study where, and he may have said this, so I might be repeating last week's podcast, but he said that the average buyer thought a buyer agent spent 15 hours with them versus the 87, which is what his study said. And I think that's shame on us as an industry for not educating and articulating and explaining. I used to say it to my buyers agents when I was production. I'll say it to my agents today. It's like, there's so many things that we do that are mundane to us because we're just so good at it and repetitive. They have no idea what you do. right? And unfortunately, in a buyer's mind, I think it's that unlocking the door and maybe sending the offer, which is maybe 10% of what we do for them, right? So the benefit that came from this is a forced conversation and like the people with great presentation skills and ways to articulate it. If you remember, I had a t-shirt over the summer I wore that said, treat your buyers like you treat your sellers, right? You didn't show up to a listing presentation and wing it. You had comp, you had examples of marketing. You said, hey, I will do a 3-point marketing program. I will send X amount of flyers. We will door knock this neighborhood. We will do this many open houses. We will do this many Facebook ads, paid and organic. We don't do that with buyers, right? So you need to be able to say, hey, do you know this will probably take 6 months. You'll get tired of seeing me. We'll probably meet 10, 20, 30 times. We'll probably write an offer. It'll fall through. We'll go have to find another one. Like, this is going to be a long-term relationship. I will be on your Christmas list when this deal is done. But I don't think we did that as an industry.
I like to tell agents when I teach this is that one of the things that I've learned in the 30 years of doing real estate closings, 30,000 closings, and it's mind-blowing, so everybody needs to write this down, but every single one of those transactions had a buyer. Mind-blowing. You got to have a buyer, you got to have a seller, right? It's like, why are y'all just pissing away half of the market? The buyer side is just as important as the listing side. We should treat the buyer side the same way. Have the presentation and master it. But one of the frustrating things that I hope you could talk about here that we're seeing is that you'll have these agents that truly understand why broker to broker needs to go away, and they aren't out advertising what the commission's going to be because we don't know what your offer is. But I had an agent the other day on a $600,000 house. Another agent who's been in the business longer than I had said, well, I didn't show your house because you weren't offering any comp. She goes, who said we weren't offering any comp? And it's like, why are agents still 6 months later, top agents not understanding, I don't need to advertise comp. It doesn't matter if I advertise, I'm going to pay you $1 million to bring me a buyer because it's not in the contract. Doesn't matter what I say.
I mean, so let's go back to a word you used very early on that's very important, which is what I reminded agents through the shift. And again, I don't relate as much to that because we were so loud in our education such a certain way. But you have a fiduciary responsibility. You get a buyer qualified, and then you ask him or her what it is I normally draw it on a triangle. It's location, price, and then physical attributes, year built, type. Once you answer the questions for all three, you show them everything available for them. Period, full stop. That's the only way how you don't inadvertently create steering and racial profiling and
redlining and all of it.
And these are all federally protected. This is orange jumpsuit stuff, not slapping the wrist from NAR or your association, right? So, and like, I've been teaching that for 23 years, right? Like, if you look at fair housing violations put out by HUD, 99% of them happen with rentals, right? Historic. And again, like, I taught a lot of classes to my agents, and I said the reason for that is because purchases are binary. You qualify or you don't, right? So if you have a pre-approval letter, I'm going to show you every single house that's $450,000 in the area that you told me that I have in my MLS email database back and forth. The second you stop doing that, trust me, you're opening a Pandora's box. And by the way, the argument, right, for the other side, like we discussed in CCP, is, well, my consumer told me that they don't. Bullshit. Your consumer told you that because you posed it as a yes or no question that was leading the witness if we were in court.
100%.
Right? Period. Right? Because if you say, hey, I'm going to do it for X, and at the time of contract, we will negotiate the seller to pay for it. And if they can't pay for it, you don't have to buy that house. Right? That's the proper way to do it, which is, I'm going to show you everything available that you qualify for in the geography that you've expressed to me in writing that you are interested in. Because anything where you don't do that, I've been in this business long enough where even if that consumer said, don't show me anything that didn't have compensation offered, 2 years from now, when you get a subpoena from HUD and says, hey, you didn't show them this house because of blank, fill in the pick your 7, right? How are you going to document and prove that that's not why you didn't show it to them? Right? Because red line is different than steering, and it's different than, ageism. Like, you better have, like, no, I showed them all. Like, check, this is the email I sent them. This is a Supra log of properties I showed them. But if you skipped over a gem of a property that was perfectly in their price point, and then, they find out that there was a commission paid out because they subpoenaed that consumer, you're going to have a fun time trying to explain what happened in the past when you don't have perfect recollection or documentation of what was said or not said.
I tell people all the time, you can't break the law because your client tells you. In South Carolina, you have to present all offers, and I can't have my client saying, well, don't bring me an offer unless it's $1 million or more. If it's $200,000, I still have to present it to you. That's the law. And just because my client says don't do something doesn't mean, oh, well, I didn't follow the law here because my client told me not to. That's not a defense before any real estate commission or any courtroom. It's just not going to work. Well, we have about 3 minutes left. I wanted to get your opinion. Now, this is probably a whole hour-long topic as well, but dual agency. I'm starting to have a lot of conversations with some brilliant minds like yourself. I think dual agency could be another one of those things that could put us at risk. I don't know how we can represent two parties.
This is a big loaded one, so I'll give you the company answer, and then I'll give you my personal opinion. So our company answer is we will support what's legally enforceable in your state, right? So with all things, Gary, I think you've heard me say this, legal, enforceable, and ethical are my three pillars when I look at opportunity or I coach agents or give advice. Now, I will tell you that when I practiced and I sold close to 4,000 homes, I just didn't do it. Like, explained it to me and I said, okay, I don't want that, right? Like the concept of giving two people fiduciary insight is an oxymoron by definition. I'm not a lawyer, but I'm good at reading words. So what I always did, it's like, hey, I picked two I represented. Like you are an unrepresented party, you're a represented party. And clearly I tended to have more relationship. Like if it was my listing and a buyer came off the street, like, I don't know you, I'm going to give my responsibility to the person who's already retained my services, right? In the off chance that it was like someone I knew, I would probably prefer it to someone on my team or in my brokerage where they're like, I live by, and I was a highly productive agent. So I already felt like I had a big enough target on my back any day of the week. So I just, simple logic said, let's just avoid stuff that creates liability.
Well, Leo, I know we're out of time today. I would love to talk with you for a whole other hour, but I know you have to go. You got another meeting. I appreciate you being on. Love to have you come back again in the future.
Likewise, I'll be happy to come back. I enjoy our conversations, Gary.
Well, you're one of the most brilliant minds in real estate, so it's always an easy conversation. Guys, that's another episode of Dish and Dirt. Appreciate y'all showing up and following us once again. If you'll please like us, share us, and subscribe to us, and come back again next week for another episode of Dish and Dirt. Y'all have a great weekend.